Moving forward, friends, it is pertinent to note that the rules of interpretation also act as a challenge to drafting of a contract. Now, in this discussion, we will have an array into certain rules and also look into certain general principles on the basis of which a contractual clause will be interpreted. Now, these rules of interpretation have been tested and tried and have been implemented by the courts on various instances. We will have a discussion of a few of the instances just to have a clearer picture of what the rules of interpretation are. On this context, it is necessary to note that there is a difference between what the textual interpretation of a contract is and what is the contextual interpretation of the contract. The courts always tend to look at not just the mere text but the contextual interpretation of a contract. That is where we had discussed as to the beneficial interpretation rule and other aspects. Please note, merely because the text is interpreted in one way, if there is any absurdity that comes to the contract, if there is any ambiguity that arises in interpreting the contract, the contextual meaning will always be weighed on by the courts for understanding the obligation of each of the parties. At this, there is this Latin phrase which I would like to mention, which stands for expressio unis est exclusio alteris, which means express mention of one thing excludes all others. Please note, when a contract is being executed, we have understood from our previous discussions as to in what circumstances drafting can make a change in interpreting the contract. You must have looked at the lecture where we made reference to payment of overtime wages. So in those circumstances, express mention of the aspect of distribution business or packaging for distribution business makes a complete differential understanding to the business which is being carried out for the purpose of distribution alone. Here further, there was a contract in Swastik Gas's case which said the contract shall be subject to the courts at Calcutta. Now please note, my friends, this is a synthesis of both fact and law whenever a contract is drafted. Ideally, in any contractual transaction or any civil transaction, jurisdiction arises on more than one place. It could be one, the place of contract. It could be two, the place where either of the parties are residing, or it could be three, the subject matter of the contract and its location, or it could be four, as to the place on which the deficiency or any other aspect arises. So this being the case, you understand that the jurisdiction of the contract can go off to more than one place. Now, what if one of the contractual clause provides that this contract shall be subject to the courts at Calcutta? Am I excluding all other jurisdictions? The observation made by the Honorable Supreme Court in this case is to be noted. It has mentioned that if a particular clause is put across that subject to the courts at Calcutta, which it means that it excludes all other jurisdictions. In this case, one of the party was based out from Jaipur and they sought to execute the contract in the courts of Rajasthan. And as such, there was an objection that was raised by one of the parties that the contract can be enforced, the contract or the case in hand can be filed only before the courts at Calcutta and not at any other courts. The Supreme Court held the view to be appropriate and mentioned that it is not necessary for the contractual clause to say courts at Calcutta alone, because they have given across one step down interpretation for contracts from statutes. In case of statutes, there is a chance for you to read into the statute for the purpose of making the statute beneficial. But however, in the case of a contract, such form of interpretation is generally refrained from. The courts held that since it has been mentioned at Calcutta, the intention of the parties was never to be amenable to the jurisdiction for the courts in Rajasthan or particularly at Jaipur. And as such, if any matter has to be filed in respect of this contract, it shall be filed before Calcutta alone. So that is what this rule expressio unis est exclusio alterius implies. The next rule is that of ejusdem generis. Ejusdem generis implements that if a particular contract has more similar words, so you will go by the generic understanding of what that particular term is. Let us say, for example, you understand this particular force majeure clause which is there before you. None of the parties shall be liable for any delay, failure in performance, loss, or damage due to force majeure events. During the performance of the agreement, events of force majeure may occur, such as, but not limited to, war, fire, flood, earthquake, accident, riot, strike, explosion, lockout, act of God, act of government authority, accidents and or damage, decisions from customer, or any event beyond the reasonable control of any of the parties. Please note, my friends, the term any event beyond the reasonable control of the parties will be read in light of the rule of ejusdem generis. In the sense, in case there is a particular incident, like say for instance in this particular strike, there is no aspect of gherao that is included. Now, in case there has been a gherao of one of the parties in performing the contract, will that be read as force majeure? Please note, by applying the rule of ejusdem generis, which means of the same nature or kind, in that circumstance, the term gherao will be read into the term strike. So, as such, this is the manner in which the rule of ejusdem generis applies to contractual interpretation. Further, we come to another question as to whether this clause can cover the COVID-19 pandemic. Yes, my friends, I'm sure you must have come across the aspect of COVID-19 pandemic and certain instances where a lot of courts have held COVID-19 is pandemic and is also an inclusion into the force majeure, whereas few of the courts have held the defense of COVID-19 cannot be held for non-performance of a contract. Please note, friends, there was a clarification that was issued in 2020 by Government of India in respect of the contractual performance in case of government contracts. And this particular limitation or circular or clarification which was issued could not be extended to all the contracts by itself, unless the contract provided for some similar nature. If you look at it, nowhere in this particular definitions, if you are to make across an instance, war, fire, flood, earthquake, accident, riot, strike, explosion, lockout, act of God or act of governmental authority, accidents or damage, decisions from the consumers, does not include anything related to diseases, epidemics, or pandemics. So, as such, COVID-19 pandemic, in my opinion, will not be read into the term by way of ejusdem generis because it is inherently a disease. It is a flu. So, as such, the term disease not being in the force majeure clause, the COVID-19 pandemic cannot be read into the contract by means of ejusdem generis. Although it is something that is beyond the control of the parties, but given that it has not been included as a force majeure event, it cannot be read in as such. Interpretation by way of incorporation. This is another addition that has been made. Now, if you look at it, what do you understand by this concept? It means that if there are certain additional documents or additional agreements that have been executed by the parties, can the second or subsequent agreement or the prior agreement be read into the new contract which is being executed by the parties? Please note, my friends, incorporation by reference or by implementation in a particular contractual clause is allowed for. So you can make a mention in the clause subject to the previous agreement executed by the parties, which means that you are giving prior importance or utmost importance to the previous agreement because you are using the term subject to. Now, if you want the subsequent agreement to get paramount, then in that case you would put across notwithstanding anything contained, which is a non-obstant clause. So using certain contractual clauses such as non-obstant clause or a particular aspect of non-prejudice clause, which is subject to, you can make across a contractual interpretation by way of incorporation. Further, there is a possibility for you to also include certain schedules or annexures to the existing or the new contract which you are executing, wherein you are including the previous agreements as well by way of annexures or schedules. This is an example of incorporating different agreements into a new contract so as to ensure whether which agreement of the two shall have a superseding effect. With this, we move on to the aspect of implications of contractual interpretation and the principles and their interface. Here we will be using certain aspects of understanding as to in what circumstances the interpretation rules have an implication on the contract. Please note, first and foremost aspect is, I think we brought this in the previous discussion, as to the use of pre-contractual discussion and negotiations. There was a particular delivery slip that was made that had a particular note which said, but if any new plating is required, the same is to be paid for extra. And upon confirmation of that, the contract was executed. But however, this particular pre-contractual discussion was not included within the contract. But nonetheless, the courts looked into the scenario and understood that since there is a particular aspect of additional cost that is involved, additional labor that is involved, it cannot be excluded from interpreting the contract. In the sense that you must have come across in the system of damages that there is also damages based on quantum merit, wherein if one of the parties is put to a detrimental position, in those circumstances, it has to be adequately compensated for. So this is the manner in which the courts can also tend to look at pre-contractual discussion and negotiations to understand the full purpose for which the contract is executed. The next aspect is the rule of parole evidence, which is covered under Section 92 of the Indian Evidence Act. Friends, please note, we spoke under Section 91 that in what circumstances the contract alone will be looked as a primary evidence. And there is no particular manner in which the contract can be looked away from or shied away from by the courts while interpreting the same. Now, the rule of parole evidence is the exception to that general rule. What are those exceptions and instances where the courts will delve into other contractual documents or other necessary facts and circumstances is covered under the Section 92 of the Indian Evidence Act. Existence of merger clauses. If there is any fact which may be proved, which would invalidate any document or which would entitle any person to any decree or order relating thereto. This is the first premise. The merger clause, it could be a particular subsequent agreement which is executed. We spoke about the concept of using non-obstant clauses such as notwithstanding anything contained in the erstwhile or the previous agreement. If such a clause is there, then in those circumstances, the courts are bound by Section 92 of the Indian Evidence Act to look beyond the terms of the first agreement to the subsequent document which is executed accordingly. The second one is with regard to the existence of any separate oral agreement as to any matter on which a document is silent and which is not inconsistent with its terms which can be proved. Now, take the example of a construction agreement. Now, if you have to look at it, once the building is constructed, there is no requirement for painting the particular building. The only obligation that is put on the builder is that please, lay out the primer and then hand over the delivery upon construction. This is the only obligation that is imposed on the builder or the constructor. Now, it may so happen that there is an oral agreement or an oral arrangement between the parties asking the builder to also paint the house. Now, in those circumstances, would the builder be entitled to costs for painting incurred and also reasonable amount of compensation? Pretty much yes, because there is a separate oral agreement between the parties asking the builder to go beyond his contractual obligations and perform the same. If you look at the contract ends as soon as the primer is laid. There is no requirement for painting. But the parties have entered into an understanding that the painting is required to be done additionally. In those circumstances, the parole evidence rule allows you to read the oral agreement for interpreting the written contract. The third one is the existence of any separate oral agreement constituting a condition precedent to the attaching of any obligation under any such contract, grant, or disposition of the property. Please note that this is a particular aspect that speaks about a condition precedent. So this covers the aspect where there is a separate oral agreement, wherein it is provided that, see, as long as you perform that particular condition precedent, you will be entitled to the benefits under the new contract. So if there is such existence of a separate oral agreement, in those circumstances, the rule of parole evidence operates to reading such separate oral agreement also into the contract. The next clause is with regard to the existence of any subsequent agreements to rescind, modify of a contract or grant of disposition of property. Okay, but there is a small aspect that to which this rule of parole evidence applies. Please note, friends, in the case of sale of property, which is an immovable property, that may be done so only by means of a written instrument alone. It cannot be done by way of a oral agreement. So in those circumstances, even if there is an oral agreement to transfer the property to another person after a sale deed is executed, the oral agreement will not be read under the rule of parole evidence because of the bounded obligation under the Transfer of Property Act of 1882 to actually exclude oral agreements for transfer of property. So in those circumstances, unless there is a written document, it will not be looked into. Second to it, even if there is a written document, there are few impositions or limitations that are created by certain other laws. Like, say, for example, the payment of stamp duty, the requirement for registration, and others. Unless a property is duly executed, and I would like to quote duly executed, which means in compliance with all the necessary applicable law and procedures, it will not be read into for reading out or interpreting an existing agreement. The next contemplation is where there is any usage or custom, okay, by which incidents not expressly mentioned in any contract are usually annexed to contracts of that description, which can be used for interpreting by way of parole evidence. Please note, friends, in certain instances, customary practices or usages are generally utilized in mercantile contracts. In the sense, most of these contracts go by way of their usage or practice. For this aspect, I would request you to understand that there are certain key terminologies that are generally used in contracts which are there for shipment. For example, if the price payable says CIF, it means that it is inclusive of cost, insurance, and freight. Alike is the case if I am to use the term FOB, which means free on board. So here, these terminologies CIF and FOB are those that have been utilized for times immemorial by those engaged in shipping businesses. So as such, the terminologies will be interpreted in the manner in which the custom reiterates. So on this note, it is to be looked at. If the contract is silent and the term CIF are read into, it means that the seller shall be responsible for the cost of transportation, for the insurance and the freight of the goods while putting it across. And in no circumstances the buyer will be entitled to incur those expenses. The last aspect that comes under the rule of parole evidence is the point where any fact which proves the manner of the language of a document, it can be used for interpretation of the contract. Now, let us say, for example, if there is a fact which provides that Mr. X has a particular object with him, and that object is described in the contract without any further description or anything of that sort. In those circumstances, the facts can be proved to understand what the terminology that is used in the contract denotes. For instance, let us say Mr. X has a antique car, and that is the only antique car which Mr. X owns. but the description of the antique car is not given in the contract, but rather it is put across in clear terms that Mr. X owns an antique car. So in those circumstances, any car which is antique in nature, which can be proved before the courts as to the aspect of its antiquity, can be used for interpretation of the contract by means of parole evidence. So this is the general outline or outlook on the basis of which a contractual document can be interpreted with evidence, either documentary or evidentiary proofs of other nature, by looking beyond the contract. Further, moving on, it is to be noted that in case of special contracts and special businesses, the implication of contractual interpretation may vary from case to case basis. Now, at this point, I would like to mention something called the principles of Brand principles, which is applicable in case of standard essential patents. Please note, this is a case where the usage of CDMA and GSM aspects were debated, where Ericsson was a pioneer in this technology. And it so happened that Ericsson was giving this particular standard essential patent, which is your CDMA or GSM technology, to mobile phones at a beneficial price to few of its joint venture partners, but whereas certain others were required to procure the same at a very exorbitant pricing. Please note, friends, this aspect of standard essential patent means that there is a particular invention which is a basic standard or a bare requirement for it to be operational. And without such particular ingredient, the product cannot by itself sell in the market. And such possession of such technological advancement puts the owner of such technological advancement at a very high pedestal and a very high bargaining power that it cannot be negated by any of the parties. In those circumstances, please note, the Competition Commission has interfered and held that clauses relating to standard essential patents have to be fair, reasonable, and non-discriminatory. Non-discriminatory principles have also been read into private contracts, especially in the case of standard essential patents. And this being a special contract, it quite gives a perspective that in case of special contracts, the rules of interpretation can also have a slight variation in order to protect the interest or the larger public interest at hand. With this, we move on to further additional rules in the interpretation to the contracts. The first query that comes across is, can an allegation of fraud vitiate a foreign contract? Can arbitration proceedings be initiated where a CVC inquiry or probe is in process? This is the particular point that is to be looked into. The courts have time and again held that fraud as a particular aspect is something that the arbitration tribunal can look into as long as it relates to the civil liability. But whether a mere allegation of the existence of fraud stall the arbitration process, this is the interpretation that has been taken in a 2014 decision of the Honorable Supreme Court. Please note, a mere allegation of fraud by itself cannot vitiate arbitration proceedings. It has to be proven, and only then in that circumstances, depending upon the nature of the fraud and its implication on the implementation of the contract, it can affect the same. The next point that we have to look across is with regard to the survival of arbitration clause. Please note, friends, there are multiple clauses that are generally given across as to in what circumstances a survival of an arbitration clause takes place. Please note, in case a contract is terminated, would it allow for the arbitration clause to survive? The answer is typically yes. In case of termination of the contract by one of the parties and not by both parties, the arbitration clause survives the contract. What about the case of repudiation of a contract? Please note, an arbitration clause survives even a repudiation. What about frustration? When a contract becomes impossible to perform. What happens in the case of frustration when a contract becomes impossible to perform? And in the case of rescission, where one or more of the parties rescinds from performing the contract. Now, this is a slight aspect that needs to be looked into, where a contract becomes void on account of force majeure. In those circumstances, still the arbitrator has the power to go ahead and look into the validity of the contract as to whether there has been an instance of frustration or impossibility of performance as provided under section 56. But however, in the case of rescinding of the contract with the consent of both the parties, in those circumstances, the arbitration clause ceases to survive because it is a volition which is carried out by both the parties. Unless the consent of both the parties is available for a contract to be put an end to, the arbitration clause survives regardless. Instances of non-survival: novation and waiver. If a contract is novated in the sense that the parties enter into a fresh agreement and clearly stipulate that the erstwhile agreement is no longer in existence and has been amended or modified by way of novation, in those circumstances, an arbitration clause does not survive. Second aspect is that of a waiver. If one or more of the parties put across a waiver stating that we hereby waive the requirement for an arbitration, in those circumstances, an arbitration clause can be waived and as such will not survive the termination or repudiation of the contract. However, friends, here it is pertinent to note that when a particular agreement for arbitration is required to be in writing, the same which is to be novated or to be waived off also has to be in writing and cannot be done by means of a mere oral agreement. Choice of laws in an arbitration clause. Now, please note, friends, in case the parties to a contract are Indians, then in those circumstances, the rules of interpretation provide that even if there is something contrary drafted, the law that is applicable is the Indian law alone. You cannot have any foreign law which can be read into an arbitration clause. The rules of interpretation of an arbitration clause in escalation or multi-step clauses. Please note, friends, escalation or multi-step clauses are where there is a step by arbitration that is created across in a contract, in the sense that the first premise or at the first instance, the parties are required to settle their disputes by way of a negotiation. They are required to send notice to either of the parties and thereafter attempt negotiation, and in case of failure for negotiation, they have to look at arbitration as a mode of recourse. In those circumstances, the rule of interpretation would be that unless step 1 is satisfied, you cannot go for the arbitration aspect at all. So therefore, escalation or multi-step clauses in the case of a contract are required to be complied with before moving to the second step or the third step, which is provided under multi-step clauses. Forced arbitration. Please note that an arbitration clause is something that has to be voluntarily signed by either of the parties. So forced arbitration in certain circumstances, especially when parties are not on equal footing, will not be enforced by the courts. But however, if there is a business transaction that is on place, then in those circumstances, the forced arbitration will also be accepted by the courts for interpretation purposes.